Meg.
You have the right to remain
Silent.
Where'd you hear this phrase?
America.
Can you tell me more specifically?
The Constitution is the like Sixth Amendment, maybe?
Okay, amazing. Thank you.
Richard, you have the right to remain.
Silent.
Where'd you hear this phrase?
TV.
Mary, you have the right to remain.
Silent.
Where'd you hear this phrase?
The Constitution. No, the Miranda law rights.
Yes!
Everyone in the United States has rights they are free to exercise while in custody. However, as has been demonstrated, an understanding of these rights is lost among Americans. Additionally, only 3% of people are even aware of their legal rights. Miranda rights could greatly transform the outcome of a case, and the addition of these warnings had been created to ensure a knowledge of the rights Americans are provided under the Fifth and Sixth Amendment. To further explain the significance of Miranda, we will discuss the criminal justice system pre- and post-Miranda, and why education on Miranda rights is fundamental to justice. Police interrogation had been regulated and monitored by the Fifth and Sixth Amendment to the U.S. Constitution since the late 19th century. It wasn't until much later that the Supreme Court began to notice a common problem when suspects confessed. They were unaware of their rights. While the amendments had been present in the Constitution years before Miranda rights became a requirement, the rights of citizens were violated while in custody. One case in particular became the spark for Miranda rights. In 1963, Ernesto Miranda was arrested in his home for robbery and rape. When he was taken into custody, he was interrogated for 2 hours by 2 law enforcement officers. Soon after, Miranda produced a written confession to his crimes and was sentenced to 20 to 30 years by the Arizona Supreme Court. The case of Miranda versus Arizona eventually made its way up to the Supreme Court of the United States. The lawyer of Ernesto Miranda, John J. Flynn, believed that Miranda's constitutional rights were violated because he was not informed of them. What you are about to hear is audio from Miranda versus Arizona, as heard in the Supreme Court.
No, the attempt to erode or to take away from him the Fifth Amendment right which already existed, and that was the right not to incriminate himself and to be convicted out of his own mouth.
Well, didn't he have that right earlier?
If he knew about it.
Before this became a so-called adversary proceeding?
Yes, Your Honor, if he knew about it.
Why
He was
didn't
aware of it. If he was knowledgeable.
Then didn't he have the right to a lawyer's advice earlier than that?
If he could afford it, yes. He was intelligent enough, strong enough to stand up against police interrogation and request it, yes.
The Supreme Court agreed that Ernesto Miranda's constitutional rights were violated, and then ensured that every suspect must be informed of their rights upon arrest. These are called Miranda rights. Miranda versus Arizona quickly changed the way the United States handles arrests and interrogations. The typical Miranda warning goes something like this.
Is you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney present with you while being questioned if you wish. If you cannot afford to hire an attorney, one will be appointed to represent you before any question if you wish. You can decide at any time to exercise these rights, not answer any questions or make any statements.
Some may believe that this is a bureaucratic process that doesn't hold much weight. Others believe that you have the right to remain silent is just a complicated way of saying you are going to jail. Whatever one's belief may be, more likely than not, they are not knowingly and intelligently waiving their rights. Understanding what Miranda rights entail is essential to protecting yourself while in custody. A detained person can choose to use or waive their Miranda rights. By law, police may only interrogate a suspect after he, she, or they have been read their Miranda rights. The suspect must waive their rights voluntarily, knowingly, and intelligently. If someone chooses to speak when they have the right to remain silent, they are waiving their Miranda rights. One common problem consistently arises. People don't understand their rights. We had the opportunity to sit down with a sergeant of the Highway Patrol, Greg Prim. Here's what he had to say surrounding Miranda rights.
Sadly, I don't think a lot of people take the time to read the Constitution, especially in a circumstance where they're under stress or whatever. Even though that it may seem redundant, these people understand that they do have the right to remain silent because they understand the Fifth Amendment. That, I think they need to understand it's kind of a bright line instance in my contact with that person that says, we're getting to serious stuff right now, and you need to understand that you have these rights afforded to you, and you don't have to make any statements. So I think it's important that we continue to do that in law enforcement.
The frequent lack of understanding of Miranda rights impacts clients significantly in the court of law. We had the chance to speak with a former public defender, John Parker, on the topic.
In my experience, over 90% of my cases, and that's just a statistic I'm pulling out, but it really did feel that way, were people who did not graduate high school. So you're dealing with an underserved, funded population, right? Like these people they didn't have a government class that they went to because they didn't go through the 10th grade, right? So they don't even know that these rights exist, period. They think that the police are there to like help them, or they have their own shared experience with the police not helping them. And they've like maybe been through the system in some capacity, but like people will often incriminate themselves even post Miranda. I truly do believe that education is power, right? So when I say I don't remember many of my clients having an associate's degree or having a high school diploma. A lot of people would get GEDs because the Missouri prison system offers a GED, and a lot of my clients were like, recidivism people who have had like issues for quite some time. But if we are able to fund education in a capacity that would allow them to really focus on high school graduation, right? Because like I took a government class when I was in high school, but like it's because I got to that grade.
Yeah.
Right? Like you have people leaving in 9th grade, 10th grade, like the highest level they've completed, they're already at such a disadvantage.
Yeah.
Because they don't know these rights exist. They don't know what's going on. They also don't have the ability to, really kind of like, a lot of places require you to have those things to even work there or whatever, right?
At the end of the day, education becomes the root of the issue. In order to achieve justice, we must start in education. When a suspect waives their Miranda rights without significant comprehension of what it means to waive your rights, this results in a clear violation of the knowingly and intelligently waiver. Suspects should not be expected to fully understand the weight of 4 sentences that are told to them in an already stressful situation. A written waiver does not make the issue any better. A 4-sentence explanation of rights is not enough.